You're tuned in to Agriculture Today, and we start our Wednesday show with some information from K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Today, you wanted to share some information about a recent court case between farmers. And so, Roger, could you share with us some information about that case?
Yeah, Shelby. This is a court decision from the Kansas Court of Appeals that just recently came down. And it's a very important case for farmers in the state. It does uphold private property rights. It upholds the rights of farming operations as against larger farming operations that would do them damage, particularly on a nuisance type of action. It comes to us from north central Kansas, and it involves a really, really difficult situation that's been brewing out in that county for some time.
And from the beginning of this case, from my understanding, really started with a disruption and road right-of-way.
That's ultimately what is involved here, but what you had was the defendant in this case, who's got a hog operation. It's a large farming operation. One aspect of that is a hog operation. And he had a problem with the hog waste. He needed to dispose of that hog waste. Now, in other parts of the country, such as in Iowa, where major hog production occurs, much more so than in Kansas, it's very common for a manure easement to be acquired by the party that needs to dispose of the manure. They'll buy an easement on somebody else's land, and they'll pay for that, and they'll dispose of the manure there. That didn't happen in this situation. What happened was this individual owns farmland all over the place, and he thought it would be a great idea to install about 2 miles of pipeline in the road right-of-way next to a public road to transport liquefied hog waste to spread on his crop fields several miles away. So he did. He installed 3 underground pipes, 2 to carry water to his hog operation, 1 to carry the effluent back to his crop field, passing by his neighbor's farmland. And he didn't get their consent to do that. They didn't agree to allow him to use the road right-of-way along their road frontage. And the pipes ran a mile along each of the plaintiff's road frontages, so 2 miles long, and that liquefied manure was sprayed then from a pivot irrigation system and an end gun across the road from one of the plaintiff's homes. And the plaintiffs are also farmers in this case. They sued for trespass. Look, you use the ditch right away without our permission. That's our private property. You trespassed. And nuisance because of the resulting odors and the flies and the stench created by manure being spread 200 feet from the plaintiff's home, with some of the spray drift actually covering the wife of one of the plaintiffs and then plastering the side of their house and creating just an absolutely atrocious situation.
And these unfavorable conditions even caused one of the plaintiff's family to move away.
Yeah, it did. The wife that got sprayed with the drift of this from the irrigation arm, they have a second home in Nebraska, and so she went there and had been there for a year and hadn't stayed at the Kansas home because of this problem. And that farm family even was in the process of selling some of their farmland to one of their farm tenants, and that transaction fell through because the tenant said, I can't deal with the odors around your property, and so that land transaction fell through.
Roger, what claims were made in this case, and how did they come about?
Well, there were 2 claims that the plaintiffs made. They made a claim for trespass, and they made a claim for nuisance. And the trespass claim basically was pretty simple and said, look, we didn't give you permission to use the road right-of-way, and you don't have legislative permission to do this, and you're using it for your own private purpose, and it's not a public purpose. You know, if you're a utility or a phone company, something like that, then you can use the right-of-way for a public purpose without our permission. As long as you're not interfering with traffic, that's fine. But you certainly cannot do that under Kansas law for your own private purpose unless the landowner on that adjacent land consents to your use of the right-of-way, again, not interfering with traffic, or if the legislature allows you to do this. So the landowners didn't allow this, and the defendant in this case did apply a lot of pressure to the legislature to get legislation through that would allow him to do this, but a proposed bill died in committee on this. So he never had legislative approval. He never had the county's approval. He never had the adjacent landowner's approval, but he still went ahead and installed these pipes, and it created quite a scene. With the county sheriff coming out telling him to stop, he kind of ignored that, went ahead, finished the project because it was almost done by that time. and ignoring the advice of the county attorney when the county attorney said, look, you've got to get people's approval, and that was the county attorney's advice to the Board of Commissioners. And there was also, the court indicated, some misleading comments that the defendant made to the Board of County Commissioners, making them believe that he'd actually obtained the adjacent landowner's permission to use the road right of way when he hadn't. And so they never signed off on his permits to put this in. And so it was a mess all the way through, a confusing, tangled mess. So that was one of the assertions, was the trespass claim. And then there was the nuisance claim based on the odors. And he tried to assert that the right to farm law protected him, but the court said, no, it doesn't protect you when you're not in compliance with state law, and trespass, the common law of trespass, is part of state law, and your nuisance is as a result of your trespass. So the right to farm law doesn't protect your conduct.
Roger, did the plaintiffs recover money from this ordeal?
Yeah, they did. At trial, the jury returned a verdict of $126,720 in property damages total for the plaintiffs, plus $2,000 in nuisance damages to one of the plaintiffs. Plus, they added on $50,000 of punitive damages. Now, punitive damages are rare in a tort case. They are applied when the court believes that the defendant's conduct is just willful and malicious and just reprehensible. And that's actually the words that the court used on appeal in upholding the jury's determination and the trial court's decision in this case. They said that that punitive damage award is appropriate. The witness testimony was persuasive. The wife hadn't stayed at the home for a year. They couldn't host guests. The house was coated with flies. There was a stench. The spray drifted onto the wife. That's why she left. The smell, they said, was just as bad inside the home as outside. And this was all backed up by witness testimony and other people in the area. And then the court noted that after the lawsuit was filed, the defendant sprayed twice as much fertilizer as he had the prior year. And the court said, look, that's willful conduct. And he had also piled truckloads of manure across from the plaintiff's home for several days straight after the lawsuit was filed. And the court said, that's just reprehensible. And so they hit him with $50,000 of punitive damages. And the defendant argued that that was too high. But frankly, in looking at this and based on other cases I've seen, I think that was pretty low. I think he got off pretty easy with respect to that.
As this court case has come to a close, kind of what does it mean for farmers and agriculture?
Well, this is a really important decision for farmers in Kansas. It upholds property rights, and particularly the issue with respect to the use of ditch rights of way. But you cannot abuse somebody else's use and enjoyment of their property without being sued for nuisance. And you can't use the right to farm statute as a shield to protect you in these things if you're not in compliance, if your own operation is not in compliance with all applicable rules and regulations at both the federal and state level, and that includes the common law tort claims that might be there, such as trespass. And they tried to kind of thread the needle on that point, but the court said no. When the legislature said you have to be in compliance with all state laws, that means state common law also, which is the law of nuisance. And the other thing this points out, Shelby, is we need to be good neighbors. And this is the unfortunate aspect of this. You don't want to end up being a pariah in your own community and create strife and heartache for lots of people involved. These decisions and this type of conduct last generations. I could point you to cases in Vermont, cases in northwest Missouri from back in the 60s and 70s and in the 80s, where in those communities there are still broken relationships and hard feelings because of nuisance-related issues that occurred generations ago. These things are very hard to put aside, and they fracture rural communities. So we really need to be good neighbors on these things, and the court's decision really, I think, helps point us in that direction. If
producers are wanting to dispose of their liquefied hog waste, they can still do that. Just make sure everyone's on board that you would be interacting with.
Yeah, that's right. And KDHE was asked whether they had involvement in this and had regulatory authority over this. And they said, look, we don't govern the manner in which the waste is transported to a field. That's not their bailiwick. So They don't play in that sandbox, and so they didn't have an issue with respect to the lines. But yes, the manner in which hog waste is applied to fields, you can still do that. You just have to be reasonable in the way that you do it and not interfere with an adjoining farmer or an adjoining neighbor's rights. This was not the situation where you had a farmer that was in a battle with some urbanite that moved out to the rural area and is just taken by surprise by the odors and so forth that are in a rural area. No, this was another farm family. These were farm families that were impacted by this. And we all have to use our property in a manner that's reasonable and doesn't interfere with the rights of our neighbor to use their property in a reasonable manner. And the court's decision really upholds that.
Roger, I appreciate you taking the time to join us once again this week to discuss some things related to agriculture law.
Thank you, Shelby.
That was K-State and Washburn law professor Roger McEowen.